Can you guys hear me? Tom, I sent you a text. God, I just saw, wow, I can see, oh, sorry.
There you go. Sorry, we were muted. My mute master was not here.
He's fired.
Sorry, Kath, we were just explaining what the elements of the bill here were and the history of the language that's in this bill now. And so you missed that, but it's basically it's material that came out of
Sorry.
in response or as an adjunct to the sexual harassment law that we passed in 2018, employment law. And so again, there's a long history with this language, which is not to say it can't be worked on. Of course, we're going to look at it, but it is language that has been worked on in both bodies. It has passed both bodies, just not in the same year or not in the same biennium. So, so Damien, please take it away.
For the record, Damian Leonard, Office of Legislative Counsel. So let me pull the bill up on the screen for everyone here. And all right, so this is S-103 as it passed the Senate. The first section is our Fair Employment Practices Act. So it makes several changes. The first is, you'll notice here on line 11, we're adding the word, and line 16, we're adding the words harass or before discriminate. Harassment, discriminatory harassment, whether it's sexual harassment or harassment based on another characteristic, could be religion, race, national origin, etc. That's all covered under discrimination currently. We're adding the harass and then defining what harassment is in this bill, in part because harassment is looked at through the lens of the severe or pervasive standard, meaning in order for harassment to be unlawful, it needs to either be severe or pervasive. And we'll talk briefly about that standard and the reason why this bill is proposing to change the standard. I would defer to the advocates to speak to you about, again, what the impact of that would be and whether that's something that you may want to do or not. So, but that's the first piece here, is we're adding harass because of the change to severe or pervasive. In subdivision 4, it looks like we're making a big change here, but if we scroll down to page 2, what you'll see is I've really just taken the existing language and I've rewritten the sentence because it repeated part of what's in subdivision 1 and then set things out in kind of a funny way. So the new sentence here just says that it's unlawful for a labor organization, a labor union, to limit, segregate, or qualify its membership because of race, color, religion, etc., all the protected classes, or against a qualified individual with a disability. We've taken out the to discriminate against any individual because that's covered in subdivision 1, which expressly prohibits discriminating against any individual on the basis of a protected characteristic. So just cleaning it up a little bit. In subdivision 7, the Senate is proposing to add race, national origin, and disability to the equal pay provision in our Fair Employment Practices Act. Before I go further, I should emphasize that paying to people unequally on the basis of a protected characteristic is discrimination and is prohibited by law without making this change. This is calling out the policy in Vermont and the view of the state that in addition to requiring equal pay on the basis of sex. The state also believes people should be paid equally regardless of what their race, national or national origin is, or whether they're a qualified individual with a disability. That last piece is important. So when we say qualified individual with a disability, we mean that the individual with or without an accommodation can perform all the essential functions of a job. So if you have a disability such that it prevents you from performing the essential functions of a job, even if you're provided with a reasonable accommodation, your employer is allowed to pay you differently because you would be doing a different job. So if you couldn't perform all the essential functions of a job and had to perform a trimmed down version of that job, even after being provided with a reasonable accommodation, your employer can pay you differently. If, however, you can perform the same job, your employer cannot pay you differently, regardless of whether it requires an accommodation or not to perform that job. So that's the important difference there. There were some questions in the Senate about, well, what if somebody can't lift the product in the warehouse or something like that? And the reality is, if someone can't do a certain function of the job, they're performing a different job. And so we're talking, it's not an apples to apples comparison anymore. If, however, it's about operating a particular machine or performing specific tasks, and with a reasonable accommodation, the individual can do all of those essential functions of the job, you cannot pay them differently. It would be discrimination under our existing law, and here we're calling it out expressly, saying you can't pay people differently just because one person has a disability and the other person does not. Does that make sense?
So if someone is injured on the job, and they are no longer able to, so they have the same role, they have a job, they're employed, they become injured on the job, and then they have to have modified version of work when they, upon returning. Do they then get a decrease in pay? So, or does this impact that, or no? It's
No,
higher.
so we're dealing with the kind of, that's dealing with the collision of two different laws. So the first is workers' compensation, which provides for, so potentially light duty is often given to someone who's receiving workers' compensation. So maybe they work fewer hours or they transfer to a different job. And then the workers' compensation helps, provides for their medical treatment and may provide some wage replacement if that alternative job doesn't pay as well. On return, if they have a permanent disability resulting from the workplace injury, then they would fall under the protections for disability. So at that point, if they return to the same job, but they just require an accommodation to be able to accomplish the job, then no, the employer can't decrease their pay. If they return to a different job with the employer, they can be paid commensurate with what that job is. So sometimes what you'll see is they'll return to a different job and that job has a different pay grade to it. Ideally, they should be returning to something as close as possible, but you may have a situation under the workers' compensation law, it's a little bit different than our paid leave law where it requires that you return them to an equivalent job. Under workers' compensation, you're actually not guaranteed to get your job back with the employer. And then the way the job protection works is, say you had a permanent, temporary total disability. So meaning you were temporarily unable to work at all because of your workers' compensation injury. At the end of that disability, when you reach your endpoint, if you have a permanent partial disability, meaning your capacity to work has decreased because you have a permanent disability resulting from your workplace injury, saying capacity to work is decreased is not a good way to phrase it. But your ability to perform your former job has been affected because you have a permanent disability now. At that point, your employer, there is, if it's within a certain time period, there is basically a sort of a first right to a job offer if there's an opening with the employer, but they're not required to give you your job back. The workers' compensation, though, is required to cover that injury in the long term. And so that can take different forms, and it's going to be case by injury, but it includes medical treatment, rehabilitation. It may include permanent wage replacement or a lump sum settlement to compensate for the lost income potential that the worker has. So it gets complicated, but basically when you go back to work, if you have a permanent disability, you do have protections against discrimination on the basis of that disability, but you're not guaranteed necessarily the exact same job. So.
Representative Howard and Lavani.
Thank you. I thought if an employee went back to work and was offered not the original job he or she was doing, but something comparable, that their salary would stay the same, but they would not be able to receive like an increase.
So that's dealing with family and medical leave versus workers' compensation. So workers' compensation, let me just pull up the law here. So we are getting a bit far afield.
Oh, yeah.
But let me just pull this up.
Some of the language that follows, some of the existing law that follows in S-103, is that applicable to what we're talking about?
We don't get into
screen right now, so.
yeah, we don't get into the workers' compensation issue as much. So S-103 really deals with when you have an employee who has a disability, and disabilities, it's really important to note too that disabilities are not all apparent.
Mm-hmm.
So, an individual may look like they don't have a disability, but they may have some limitation on their ability to perform their work. And disabilities are also unique. Not every disability. So disability is a condition that limits an individual's ability to perform a major life activity, which can be walking, thinking, breathing, eating, sleeping. So any number of things, and some things may impact your abilities to, for example, focus for a long time at a particular job. But they may not affect your ability to do certain types of physical labor, or maybe you have a disability that limits your ability to type quickly, but there are other ways you can get around it. You can do a speech to text translation would be a reasonable accommodation that would allow that individual to perform clerical work and accomplish all the major functions of the job. So each disability, the point is unique. And what 103 is dealing with is discrimination on the basis of a disability, and how you need to, as an employer, provide reasonable accommodations to allow the person to do their job. With workers' compensation, is basically dealing with how do we compensate and take care of an employee when they've been injured at work, and what are the employer's obligations there. So that's, I think, the best way to think about it. And so under workers' compensation, the ideal is that the employee heals completely and is able to return to their old job. The reality is that's not always possible. Depending on the injury, depending on the circumstances, that's not always possible for the employer. So the job protection guarantee that you have if you have an out-of-work medical condition does not necessarily apply in workers' compensation because you may not be able to perform your old job and your employer may not have an equivalent position available. And that's the challenge. So do we want to go into the statute or should I keep going with 103?
103.
Okay. Great.
I've got two questions lined up from Labonte and then Krasno.
How does longevity pay fall into this? With, like, let's say I've been in the machine shop for 15 years, I'm making $25 an hour, and Representative Krasnow got hired, and we're doing the exact same job, but she's starting out at $18 an hour. Would that be a discrimination?
No. So let's go back. That's an excellent question. So if we go back here, let's see, I think it's in the bill.
That's not a, that's not a, well, it could be a sole no, but it's, like everything else, I think it's a depends, right?
No.
What if she has 15 years of experience in a different shop and
What about that?
I'm looking at longevity, and I mean, and a specific employer.
Yeah, so here we look at the statute. So an employer is allowed to pay different wages when the differential is based on seniority, merit, system in which earnings are based on quantity or quality of production, or a bona fide factor other than sex. And in this case, it's going to be other than sex, race, national origin, and disability. And then the employer asserting that the wages are paid pursuant to that factor is also given the burden, if there's a claim that they're not, of demonstrating that the factor does not perpetuate a differential in compensation that's based on that factor. So, just to give an example, so an example for sex-based discrimination might be saying, well, women produce less at this point, or they have lower sales numbers. And that may just be, so that is a sex-based claim that doesn't necessarily reflect the employee there. And so just saying, well, I pay all women less because historically the women produced less in my shop doesn't justify paying the women less. You could adopt a commission system or something like that that reflects actual production and then allow people to, you could see differentials there. That's permissible, or reflects actual pieces produced. But just saying, well, women aren't as capable in this job or something like that is not a justifiable position. And that would be something that perpetuates a sex-based differential in compensation. So that is what's prohibited here. So if they are claiming that this is a bona fide factor other than one of these protected categories, they have to show that it's not perpetuating some stereotype that is, whether it's a societal stereotype or a stereotype within that workplace, they have to show that it's not just perpetuating that instead of actually reflecting a bona fide factor. Getting back to your example, what we're looking at there is potentially a seniority system. So say you're in a workplace where there's steps and every 5 years you go up another step in compensation or something like that. And that's just the way the shop works. So it's time with the employer, and maybe there are factors within those steps, but you're at step 5 and Representative Krasnow's at step 1, then you've got a situation where, yes, that's potentially bona fide there because it's a seniority system and everyone is on that seniority system. And when she reaches step 5, she will make the exact same amount as everyone else at step 5. Then that's okay. But if it's simply that all the women in the shop are at step 1, not okay. Particularly and regardless of how long they've been there, they're just kept at step one. That's not okay. So that's what this is reflecting here. And so the merit system is permissible. It is extremely problematic because merit systems can be extremely subjective and are subject to unconscious biases. But it is a permissible system, and if you do it carefully and it reflects differentials that are based on actual merit and don't reflect some sort of inherent biases, then it can be protected. But this is what's permitted under this law. And what we're doing in the bill is we are expanding it to include race, national origin, or physical or mental condition, which is a disability. So you cannot, so that's, it has to be a bona fide factor other than that. And you then have to show that it's not perpetuating a differential in compensation that is based on that factor. So again, if there's a historical differential in compensation, and this is just some sort of code to perpetuate that historical differential that's in compensation that's been provided, that's not going to stand up. You need to show that it actually is a bona fide real factor that leads to the difference in compensation.
I'm sorry.
My question is very brief. For clarification, this is just people, is this related to hiring practices or just people who are employed?
So this is just pay for employees.
Got it. Thanks.
We do have some other statutes related to hiring practices, including not requesting someone's salary history.
Yes.
So Vermont does have that.
Right. Okay. Yeah. Someone recently was like, they're not going to hire a lot of women because they're going to know that you are going to want to take time off your generation to have children. So they're not going to be, and I'm like,
that would be covered under the discrimination, which
Okay.
is 495A1
Right.
through 4.
okay.
And so if you can, in a situation like that, what you're looking at is, are they specifically discriminating against, say young women, because they're assuming every young woman is going
Right.
to leave her job for 12 weeks to have a child and then do it again in 2 years, and
Exactly.
or whatever it is that their assumption is. If that's the basis, I mean, then you've got a pretty clear sex-based discrimination, even not going into the assumption about starting a family, just showing the fact that you've had, 12 women and 12 men apply for 8 jobs, and all 8 of the jobs went to the men. And if we took the names off of the resumes all look identical, essentially.
Right.
Then we have a really strong case that there's sex discrimination going on.
Okay. Thank you
So-
so much.
That said, I just want to emphasize that you have a strong case, but these things are extremely difficult to prove in court. Discrimination cases are challenging across the board. So I don't want to oversell how easy it is to get protection under the law, even though it's there.
Right. And if people
So-
have the capacity and understanding and the time and the privilege to work on that too.
So yeah, I don't want to minimize that,
Yeah.
but I just wanted to use that as an example of, at least on paper, that's a strong case.
Thank you.
Court, unfortunately, is often more challenging than just looking at something on paper.
Representative Justin Tangent. And we will have Damien to finish the bill. I'm not rushing him through because I had a feeling that this would happen, and we do have a block after the floor today. So even though this is a 10-page bill, this is an important conversation to have.
Section 1 lays out 12 protected categories.
Mhm.
Going forward, it specifies 4. Are the
So-
other 8 included, implicitly included, or?
So with the equal pay, and Boryang and Julio Thompson did a much better job of laying out how to think about this in the Senate than I've done in the past, but I'll do my best. So with equal pay, what we're doing in the equal pay section is we're saying paying individuals differently based on these characteristics is against the public policy of Vermont. So we're prohibiting discrimination based on all of those characteristics, and a differential in pay is part of discrimination. So I think we can all agree that if you're paying someone differently solely because of their religion or solely because of where they were born, that's not okay. So, and that would be against the law. But under that, it's part of a bigger discussion where you look at the whole situation. Are there other factors in the discrimination? Equal pay on its face, we're saying, is illegal with these particular categories, in part because as a state, we believe that these are categories where there is a history of unequal pay, and we're seeking to correct that. So I think that's essentially what the bill is saying and what this is saying. So equal pay by itself or unequal pay by itself is unlawful with these 4 categories without having to prove more, assuming it doesn't fall under one of those exceptions, seniority, merit, et cetera. And so that's what we're calling out. There are, turning back to the bill, I know that, and I don't remember the exact testimony, but I do remember there was some discussion in the Senate with, again, Bor and Julio about why having a separate equal pay, listing everything in equal pay was not necessarily as helpful as you might think, but I cannot remember what their reasoning was on that. And so I'd recommend that you ask for them to maybe come in and testify on that and ask them questions about that issue. But certainly you could extend it to other things.
But it, as written, it covers those 4 categories, not the other 8.
That's right. Yeah. And that's previously it only covered sex, and the other 13 categories. No, the other 11 categories, sorry. The other 11 categories were not included in there. So this is expanding it to add race, national origin, and disability. And that was a policy call from the Senate. So.
Curious about that. Thanks.
Okay, page 1. I mean,
we're through page 3. So,
cruising.
we are. So really important thing to call out here before we, this next subdivision is, so as an employer, you are not allowed to ask someone about their disability or do you have a disability? So again, as I mentioned before, most disabilities are not visible. So there are numerous disabilities that you just will never know about unless the person tells you. And one of the concerns that was raised in the Senate is if we're saying now it's illegal to pay people differently based on a disability, is that going to force employers to basically say, disclose any disabilities to me on application? which is illegal under the Federal Americans with Disabilities Act. You are not allowed to say, tell me all your disabilities. The way it works under the ADA is if I'm an employee and I need an accommodation because of a disability, whether it's temporary or permanent, I go to my employer and I say, here's my situation. I need to get treatment for a medical condition I have. And I need that once a week, or say I have substance use disorder. I need to take 3 weeks off of work to go to rehab, and then I will need to do outpatient treatment for 3 months. So reasonable accommodation is a temporary leave under FMLA or PFLA in Vermont's case, and then a modified work schedule while I recover. I'm not protected with substance use disorder if I come to work intoxicated, but I am protected for the treatment I need to make it so that I can do my work. And that's mostly covered under the leave law, so that's maybe not the best example. Another example is if I have a mobility disability, putting my office someplace that's accessible, making sure that my office is an accessible office. So an office that I can get to and that I can maneuver around and work comfortably in. So you can't sit someone up the spiral stairs on the 4th floor in the attic if they have trouble navigating stairs. That's a reasonable accommodation, is to say I need to be somewhere where I can go because I can't navigate stairs and there's no elevator access to that floor. So does that, what this is saying here, focusing back in on the bill, is this is saying nothing in this section diminishes the employee's right to privacy regarding their disability or physical or mental condition under any other law, which would be the ADA and the anti-discrimination laws, or pursuant to an applicable contract or collective bargaining agreement. You might have better protections than the law provides under your employment agreement or under your union's contract. So this is just recognizing that employers are not allowed to circumvent the ADA, claiming that this gives them immunity. What this basically says is if as an employer you're aware that your employee has a disability, you can't pay them differently because of that awareness. Does that make sense? Okay. We are at the do not darken my door provision. So this subsection I would prohibit what are commonly called do not darken my door provisions. What that means is this is a provision that goes into a settlement agreement that says, as a condition of this settlement, I agree that I will never work for the employer or any parent, subsidiary, division, or affiliate of the employer at any time ever again in the future. And so what this would do is say that those are prohibited, and that any section or provision of a settlement that violates this provision would be void with respect to the individual who made the claim, not with respect to the employer. So the reason we phrase it that way is to prevent, is essentially to prevent an unsophisticated party from signing an agreement where the benefit they're getting in the agreement is in the same provision that includes the do not darken my door provision, and then to allow a sophisticated employer to back out of the claim. It's protecting the individual who experienced discrimination and has settled that claim of discrimination from potentially entering into an agreement where something that would benefit them is then there's a claim that it's void later. So basically what this says is that if I sign an agreement after this bill takes effect, so this is prospective, that's important to keep in mind, unless you notwithstand 1 VSA 214, this is a prospective piece going forward. So going forward, if I sign an agreement and the agreement says I can never apply for a job or work for the employer and any affiliates of the employer at any time in the future, and as a condition of agreeing to this provision, I'm getting an extra $5,000 as part of this settlement. What happens is, if I go to apply for a job in the future, I can't then be told that I'm in breach of my settlement and that I've lost the right to that $5,000 or whatever it is. On the other hand, the employer cannot take that $5,000 back just because I applied for that job in the future. So that's basically what it's saying, is that the settlement's the settlement, but you can't bind the person from applying for a job in the future. We do this for sexual harassment claims already. This would extend it to all employment discrimination claims. There are advocates on both sides of the issue that I'd encourage you to talk to, who will talk to you about the benefits and drawbacks of this. But this is what it would do going forward. And are there any questions on the provision?
Bartley?
Oh, yeah.
I just want to clarify, it's that the employee would have the ability to apply. The employer later on does not have to hire somebody.
That is entirely correct. Thank you for that clarification. This does not require the employer to hire that individual in the future. So an example of why that might be the case is, well, there are a couple of examples I can think of, but one, say they're applying for their old job back in the office and their relationship with their former and potentially future supervisor was just non-functional by the end of their time at the employer. The employer could say, we can't prevent you from applying, but we're not going to hire you for this position because we think it would just create a toxic atmosphere in the office. By the same token, if that former employee is applying for an affiliate, they're qualified for the job, that former employer can't then go say, nope, you're in breach of the contract for applying with our affiliate halfway across Vermont. So the places in our state where this will really play out the most is with the larger employers like the state, the medical centers, and so forth, where you have multiple offices and branches and so forth. You're unlikely to see it play out as much with smaller employers because you tend to have more focused offices. But again, it's worth hearing from the advocates on both sides about what why they see this as a good thing or why they're concerned about it. But it definitely does not prohibit an employer from refusing to hire that individual in the future.
All right, let's stop there. And we'll come back to this afternoon. Great. Committee, let's